Good morning. Good morning, everybody. This is going to be an online course of the real estate trading services. The real estate trading services course has 26 chapters in all. About two-thirds of the course is law and learning about what realtors, what another name for realtors is reps, what they must do. And one-third of it is the real estate math. So what we have here is the first chapter of the real estate trading services course. This first chapter is going to be uh, free for everybody to evaluate and see if they like the material. And then chapter 1 and chapter 2 will be free, and chapter 3 onwards, if you are getting use out of these two chapters, then you can sign up for the other chapters. So let's get started on chapter 1. Chapter 1 in our course has many topics, but we are going to concentrate on the most important parts that are part of your examination. Okay, and you know your examination is offered by Sauder School of Business. It has 100 questions, multiple choice, and we'll talk more about how to go about getting ready for the examination also. But let's first of all go through the topics that we will be covering. The topics are government, levels of government, types of law, sources of law, civil courts, trial process, enforcement of judgment if the person that lost the case does not pay, mediation, what's mediation versus discovery, CRT, which is called Civil Resolution Tribunal, and do a few practice test questions. So let's get started on the first topic. First topic is levels of government. We have three levels of government in Canada: the federal government, provincial government, and the municipal government. The federal government is responsible and owns the federal lands. Two main topics. They have jurisdictions for many other topics, but for your examination, two main topics of the federal government responsibilities are postal and fisheries. Then we have the provincial government for your examination again. Main important part is that they're responsible for our Real Estate Services Act and the education. Okay, and then the provincial government delegates land laws to the municipal government. So the municipal government, which is the city government, which is responsible for the private owned individual lands. So the main thing that we want for our examination from this is that the federal government is responsible for postals and fisheries, and the provincial government is responsible for education and real estate, and the municipal government is responsible for private owned land. And the other thing that we want to know is when we have the governments making laws, they're called statute laws, and how we recognize something is a law, something is a law is recognized by the word act. So either it'll say Real Estate Services Act or Education Act, Welfare Act. So all of these words which have the word act at the end are either federal government laws or provincial government laws or municipal government laws. So that's the main thing that we need to know for this course and for the examination. Okay, two types of law. Two types of law. One is called private law and the other is called public law. Okay, another name for private law is tort or civil law. Okay, so you need to know for your examination that under private law is basically dealings of person against person or a company versus a company. Okay, so private law or tort or civil law is anything to do with contracts between people or between companies or between a person and a company. Okay, so also private law is about divorces, real estate, negligence, anything to do with negligence, the private law is involved in that, and agency. Okay, so you have to remember that for your exam. Private law, small stuff. Public law is where the federal government or the provincial government is involved in taking care of the public. So whenever there's issues with criminal law or constitution or tax, then that is federal government versus another party, and that is called public law. So for your exam, you need to know that there are two types of law. One is called private and the other is called public. Private is the small stuff between people and between a person and a company, and the public is between the government and the person. Third topic. Third topic is sources of law. Okay, we have three sources of law. When a judge has a case that he's hearing, he has three options, three types of law that he could look at. One is called common law. Okay, common law is from hundreds and hundreds of years ago, that when England came to Canada, basically Canada used or started with the laws that came from England, which were called common law. Common law is still being used. Okay, this common law is the oldest. Then, because common law was many times very unfair to the person who lost the case, sometimes a person who lost a case, let's say someone who loses a case of losing, someone steals their dog, and the judge now only had one course of action after he found the guilty person who stole the horse or stole the dog. Even though that dog could be standing right in front of him, the judge had no power to give the innocent party the dog back. It only had power to give what's called damages. Okay, under common law, there's only one thing that the judge could do after he had decided who is the guilty person and who is the innocent person, and that was called damages. Second part, which is called the equitable law, and equitable law came about because common law was very, very rigid. There was only one outcome that the judge could give, and that was money for loss of not having that dog. Even though the dog was sitting in the court, the judge had no power to have the guilty person return the dog to the innocent party. In equitable law, which was developed because of this problem with the common law of only having one remedy, was developed by the kings and the queens of couple of hundred years ago. Okay, so equitable law is number two, and then because common law was very, very rigid, and again, it only had one remedy, statute law was developed by governments. So statute law is government-made law. Common law is law made by judges. And equitable law came about because common law had only one remedy. And the statute law also came about because there was only one remedy in common law. So both equitable law and statute law came from common law. There are still some situations where the judge can only use the common law because there are no situations or no laws of equitable and statute that the judge can rely on. So let's go through each one. I've given you a little brief introduction to each one, but let's go more depth into each one. And in our examination, usually there's one or two questions from common law, and maybe one or two from equitable law, and maybe one from statute law. So let's go through it. Okay. Common law, if you see the picture here, it's the picture of England, and basically it came from courts of England. 200 or 300 years ago, common law came we used Canada picked up common law because most people came from England and they brought that law with them because there was no law, no other law in Canada at that time. So what you need to remember about 5 things for your examination regarding common law. First is it was law made by the judges. Okay, not government, but judges. Okay, now when the judges made this law, they needed to make sure that there is some system that they could use. And the system that was used is what's called principle of precedence. That means that whatever has been decided by a previous judge, that will be the source that the judge will use for any case that he has in hand at that now time. Okay, so whatever decision was made by a previous judge, that would be the same decision that would be used by any judge that had the case later on. Okay. Okay, so the word precedence, very important for your exam to remember. It's a previous case or legal decision that is going to be used in the case at hand. Priority, the word priority means what's more important. Let's take a look at another principle called doctrine of stare decisis. Stare decisis. Okay, and basically, the concept is that judge will follow a former decision. If he can find an exact similar case, then he will use the outcome of that case as the outcome that he has to make for the case that he has in hand. Okay, so the word stare decisis is a definition that will definitely be on your exam. Basically, it means the former decisions are used to make latter decisions on cases being heard at the time. Okay, what this does is it creates what's called uniformity, meaning consistency. So even the criminals would know that, hey, if I do this crime, this is what's been already outcome by a judge. I will also get the same outcome. Okay. Now, sometimes the case is similar, but not exactly. Then the judge's job is to distinguish. Distinguish means to see if he can find the facts that are very, very crucial, but they're different, slightly different. If the case is slightly different, then he will not use the same outcome. Okay, so if the situation is exactly the same, that is called stare decisis. Then the judge will give the same outcome. If the if the evidence is different, if the case is slightly different, then judge will distinguish if the facts of former case are different or are not present. Then the judge will have to show that, and the judge will make a different decision. And also, sometimes if the judge cannot find a case at all within BC, then he's allowed to, he's required to look anywhere in any of the provinces or the Yukon territories or anywhere in the Commonwealth countries. So common law was very, very rigid. And why is it rigid? Is because it only had one type of remedy or reliance. After the judge found one of them to be guilty, the judge only had one remedy that he could put on that one guilty person. And that was what's called damages, which is money that would be given to the innocent person by the guilty person. Even though if the person stole his dog or stole his horse, the horse is still with the horse, and the dog will be allowed to stay with the guilty person. And that's why equity law was developed. Continue. Okay, so because of the stare decisis, this is a Latin phrase, okay? Basically it means that former decisions are used as a basis for latter decisions. And because of that, a person who does a crime will know what exactly will be happening to that person. Okay? Judges created uniformity by having the decisions, using the same decisions on the same facts. Okay? So stare decisis, judge will follow the decision of a former case because they are exactly the same facts in the case that he has now, that he's hearing. Okay? And distinguish is opposite, and that is where the judge will not follow the decision of the former case because crucial facts of the former case are not present or are not the same. Okay, so another little clarification of stare decisis and distinguish. If the facts between previous case and case at hand are the same, then the decision by the judge will be the same. If the facts of the previous case and the case at hand are not the same, then the decision by the judge will be not the same, will be different. So let's say we take a look at an example. Let's say a long time ago there was a case where Tom steals a dog. Okay, and now we have another case, let's say in the year 2021, where John steals a dog, but it's to help him through the snow. Okay, let's say in the year 1700, the judge looks at the case and the judge awarded the innocent person $2,000 for his dog, even though the dog is still sitting in the court. And who has the dog? Tom has the dog. Okay, so the judge in 1700s, in the old time, this is using common law, decided this: yes, Tom is guilty, but Tom gets to keep the horse or the dog, but the innocent person will get $2,000. Okay, let's say the similar case is in front of a judge in the year 2021, but if he feels that it's exactly the same, all the facts are the same, then the judge will reward the damages of $2,000. But if the judge feels that the crucial facts are different, then the judge will distinguish the case and the judge can give a different outcome. Maybe he would say that the dog needs to be returned to the owner, and perhaps maybe some damages of the owner who lost the dog for some period of time. So everybody see the difference. Okay, so common law, very rigid. The reason why it's very rigid, the judges found it very rigid because after the judges had decided who was the guilty person and who was the innocent person, there was only one remedy or one result outcome that the judge could give, and that was money. And money was taking the person and putting him back into the situation where he was before. Okay? And damages really are money of inconvenience to the person. The word inconvenience, so it's not really of doing the job. Damages really means inconvenience, how inconvenient the person is put. Okay, so the second type of law, or second source of law, is the equitable law. Equitable law came about a couple of hundred years ago because there was only one outcome that the judge could give to the innocent person. In equitable law, there are three outcomes that the judge could give to the innocent party. Okay, so equitable law, also called courts of equity. Another name for equitable law is courts of chancery. Okay. Developed. Why was equitable law developed? Because equitable law was developed because many results and rules in the common law were strict, rigid, and unfair. Really, it was the result that was unfair many times, because in common law there was only one end result that the judge had, and that was called damages, which is money given to the innocent person. But perhaps the innocent person didn't want money, he wanted his pet back or dog back, or if it was a contract, perhaps the innocent party wanted the person to finish the job, or perhaps the innocent person wanted the person to stop doing the job. Okay, none of those were available for the judge as remedy. So came about equitable law. Okay, so equitable rules, because equity outcomes are more relevant and more recent. We're going to talk about that. That's very important for exam questions. Equity rules will prevail. That means will be preferred by the judge. So if there is an equity law that comes, if there's a case that comes before the judge, and the judge can look at both equitable law and common law, then the judge will look at equitable law because it's more fair and it's more recent. Okay, so equitable law, again, developed because common law, the remedy of the common law, which is only one, which is money given to the innocent party, was very strict and rigid. Okay, now the judge didn't automatically use equitable law if he had a choice. He was given a discretion of the court. Judge had discretion of the court to see which one to use, whether to use equitable or common law. But most of the time he would use equitable because it was a more fair system. Okay, so it wasn't a legal right that everybody got to go to equitable court instead of common law court. It wasn't a legal right. It was a fair right, and then most people did go to the equitable court. Okay, so the equitable law had 3 remedies, whereas the common law only had 1 remedy. After the judge finds one party guilty, in common law, there was only possible to provide or give money, get money from the guilty person to the innocent person. That was common law. But in equitable law, there are 3 remedies available to the judge. One is called specific performance, or the other is called injunction. The third one is called quantum meruit. Okay, and we are going to discuss all 3 of them now. Specific performance. Specific performance is where the judge, usually it's a contract, okay, where the judge can say the contract must be fulfilled by the guilty person. The innocent person wants, let's say the innocent person wants his dog back, that means that the dog must be returned to the innocent party. Okay, basically it's more of contract. In contracts, specific performance means whatever is in the contract, the innocent party wants that done, so the guilty party must, judge will order that the guilty party must fulfill the requirements of the contract. Injunction is sometimes a person, the innocent party wants the guilty party to stop doing something. It could be stop intrusion, or stop going through their property, okay, or stop contract. Maybe there's a situation where the guilty person has started doing the tile work for the innocent party, and they're doing a very bad job, and the innocent party wants the guilty party to stop doing the tile work and perhaps pay for removing all the tiles because they were done in such a bad way. So that is called an injunction. That means stop the person, the guilty person, from doing some activity. And the third one, quantum meruit, is where sometimes it's not mentioned in the contract that how much money, and this is all about money, how much money should be given by the guilty person to the innocent person. Okay, so the judge will decide, if it's not written in the contract, or maybe the contract's only halfway through, the judge will decide whatever is fair. And the quantum meruit, again for your exam, is to know that this is a Latin phrase, Latin word, for as much as is deserved, meaning the judge will give to the innocent party as much as is deserved. Okay, so the guilty party, perhaps he's only halfway through the contract and he's done a good job, he feels it's a good job, but the innocent party just doesn't want him to continue. Then the judge will decide, look, the guilty person has done half of the job, he's bought so many supplies, and the judge will be able to make a decision as to how much is owing to the party. Okay, so sources of law, the last one, is called statute law. Statute law was developed by the governments, either provincial government or municipal government, or by the federal government. Okay, all we know anything that's called a statute law has the word act, A-C-T, as the last word of that law. Okay, and it's made, statute law is made and developed from common law. Whichever common law the government feels is not doing the job of today, they will change the common law, and that will be the statute law. And the judge now will follow the statute law as the main source of the judge deciding how to result the outcome of a case. The judge always looks at to see if there's a statute law before he looks at equitable law, and the last thing he'll look at, if there is nothing in the statute law and if there's nothing in the equitable law, he will look at common law. So it's the reverse of the way we studied this chapter. In this chapter, we started with understanding what is common law. Then, because common law was very strict, only one remedy, then became equitable law. Okay. Now, because common law again was very strict and sometimes very unfair, became statute law. Okay. Be very careful. From equitable law did not come statute law. Statute law came from common law to change some things in common law, because common law only had one remedy. Statute law, governments could make as many remedies as they wanted, or any remedy connecting to any type of wrongdoing by a person. Okay, so let's take a look at, really it's the remedies of the three laws. Okay, the remedy for common law was what's called damages. It's money, and it's not money for finishing a work, it's money for inconvenience. So if a person in the old days stole a horse or stole a dog, the innocent party would get money for the horse or the dog, even though the dog or the horse is sitting right in that court. The equitable law came about because of only having one remedy in common law. That's why equitable law was developed. And equitable law was developed by kings and queens, and it had three remedies. One was called specific performance, the second one is called injunction, and the third one is called quantum meruit. And specific performance is do what the innocent party wants to be done. Maybe he wants his dog back or horse back, or maybe he wants the person to finish the job. Injunction is sort of opposite of specific performance. It's asking, the innocent party is asking for the guilty person not to do something, either stop the work or not intrude or not cut through his yard. And the third one was called quantum meruit. That's where the judge decides how much money would be given from the guilty party to the innocent party for part of the work being done, or when perhaps they didn't mention how much work, how much money would be owing for this job, for a particular job. Statute law, remedies available for statute law are everything from money, specific performance, injunction, quantum merit, jail time, prison time. uh, all of the above are available by the government. The government would make the law, and the government afterwards would say what would be the remedies for the judge to decide on this case. So let's say we take a look at someone steals someone's dog. If it's statute law, perhaps in the statute law, maybe there might even be a bit of jail term involved in this. Obviously, there would be, a judge would have possibly a jail time and possibly return of the dog to the innocent party, and maybe even payment by the guilty party to the innocent party. So he could have two or three things all together, not just picking one item. Thank you. Okay, let's take a look at an example again. Example where Tom steals Oscar's dog. So the remedies, okay, in statute law, okay, could be jail, could be fine, could be money, could be return of the dog, okay. In equity law, specific performance would be do what Oscar wants. Probably the Oscar wants his dog back, so he'll get his dog back, and maybe Oscar also wants $1,000 because now he didn't have his dog for a couple of weeks. Okay, injunction, he may also want stop stealing any further, anything, not just his dog but other things. Okay, quantum merit, maybe the judge may be able to say, look, because of this loss, you deserve this much money. But quantum merit is more specifically set aside for part of the work, and when nothing is written, it's more contract in terms of work, okay, not really in terms of stealing. Okay, in common law in the old days, basically the guilty person would be made to provide some money to the innocent party, and judge had no power to enforce the return of the dog. Okay, let's take a look at a car accident. In a car accident, we have Tom runs over Oscar's dog. Tom is the person, he runs over Oscar's dog. Okay, so let's say the judge clearly finds, yes, Tom did run over Oscar's dog. And now, if it was statute law, maybe there will be jail, maybe there will be fine, maybe there will be money that the judge will award to the innocent Oscar. Okay. In equity law, okay, obviously the Oscar isn't going to be wanting the dead dog back. Okay, he would maybe he does want the dead dog to do a funeral, so he would be given back the dead dog. Okay, also injunction, meaning stop running over any of his dogs or any pets. Okay, quantum merit, probably no money like that. Okay, in common law, again, money from Tom to Oscar, and money would be how much the dog is worth, not just in value of the dog, but how much inconvenience Oscar has been put because of losing his dog. Okay, let's take a look at a contract where we have Harry. He's the homeowner. He hired Charlie to do some tile work. Harry now, the homeowner, fires Charlie because he's not happy with the work that Harry is doing. Okay, let's say if the judge finds that the contractor is in the right, Harry is just too fussy and maybe doesn't want to pay him. Okay, and if the judge says, hey, judge, I feel, or judge feels that the contractor has done everything. He's not doing a bad job. It's just Harry that's being too finicky and too picky. Well, according to statute law, there would be money compensation to Charlie in dollars for all his losses, for all his time. Okay. If it was equity law, basically the person wants to also end the contract, he would end the contract. Injunction, possibly none. Quantum merit now. Who's going to get paid? Well, the contractor wants to get paid. And perhaps it's not written in the contract how much work is done. If it's part of it done, how much would be owing. That would be the judge's decision to make how much as is deserved. Remember, quantum meruit means as much as is deserved. Okay, and in common law, basically it'll be again money, dollars, for inconvenience and work done by the contractor. Now, in the same situation, if the judge feels that the homeowner is in the right, if the homeowner is in the right, then compensation, according to statute law, money for and stop of the work, okay, stop of the contractor, compensation to homeowner to replace all the tile work, maybe it's not to anyone's satisfaction, okay. Equity law, end of contract, injunction, stop working, and again, quantum meruit, homeowner is given monies to replace all the tile work, okay, clean up, and in common law, compensation, damages to the homeowner to remove the tiles and all the inconvenience. Okay, so let's do a review. 3 sources of law: common law, equitable law, statute law. Okay, a judge will first see if there's a statute law that has been passed that will provide the solution to the conflict. If no statute law exists, then the judge will look to equitable law and then common law. Okay, this is priority. This is called prevail, which will prevail. Your exam questions will say, if no statute law exists, what will prevail? Well, it'll be equitable before the common. A judge may apply both common and equitable in deciding. A judge has no favoritism of which law is fair, which is unfair, because these laws are made already by the government or by common law previous judges. So the judge's decision of the previous is all finals, and statute laws are all finals. So priority for the judges, it's the opposite. It's not common, equitable, statute. It's statute first, and then equitable, then common law. Memorize the word SEC. If you memorize the word SEC, S stands for statute, E for equitable, and C for common. All your exam questions you will be able to answer because the order or the priority is S for statute, E for equity, and C for common. So when a case comes before a judge, he'll look at statute first, equity second, common third. So in a conflict, exam type of question, in a conflict between statute law and equitable law, well, let's take a look at SEC. When you do the exam, put the word SEC beside you. You know statute before equity. So statute will prevail. Statute will be preferred. Statute law and common. Statute and common. Statute will prevail, will be preferred. Equitable and common. Equitable and common. Equity will be preferred. Next topic is topic number 4, civil courts of British Columbia and Canada. Okay, and the examination questions for civil courts, maybe 1 or 2. Very, very important that you know the court system, and as a realtor, it's important that you know the court system, the court system. Basically, we have 4 courts in British Columbia and Canada. The first three are British Columbia, Small Claims, BC Supreme Court, and the BC Court of Appeal. Now, if the case does not get resolved within these three courts, then the case may go as an appeal to the Supreme Court of Canada. These last two courts here, in my opinion, this should have also had a name with the word appeal in it. Then we would know that these two courts are appeal courts. Okay, so any case that you have will start either in small claims or a BC Supreme Court. Okay, small claims are easier to work with. Usually you do not require lawyers. In the BC Supreme Court, most judges will ask the parties to have legal representation, meaning have lawyers. So now most people will start their case, or most people will take their case to what's called small claims courts. Okay, there are about 6 or 7 different cities with each having small claims court. Within Lower Mainland, we know Vancouver, Surrey, Richmond, New Westminster, they all have small claims court. So you could take your case to any one of those cities. But we're going to talk about, there are some restrictions as to which city you can take the case to. In BC Supreme Court, if you wanted to start your case there, you're welcome to start there. There are no restrictions, any other territory or money. Okay, you cannot take your case to BC Court of Appeal. It is an appeal from here to here. You cannot take your case to Supreme